Good evening. This is Laws 11046, Law and the Environment. This is week 8, and tonight we're dealing with natural resource law. There are a number of chapters in the Bates text that are catered for in this week's commentary. As you would have seen throughout environmental law, we talk about the international and then the federal and then the state and down to Commonwealth, down to council agencies. So when we're talking about protection of biodiversity, natural resource law, of course the international scope is very important. And you'll recall that we talked early on about the Convention on Biological Diversity, the Earth Summit, Rio de Janeiro, 1992. So there were many new ground reforms, through that international convention. And of course, Australia is a signatory nation to that. And part of the obligation imposed on signatory nations is to establish systems for conservation of biodiversity and biological diversity. Now, when you're considering the way in which the federal government introduced those reforms in legislation, think about the environmental, or the EPBCA. So the Environment Protection and Biodiversity Conservation Act, of course, not surprisingly, given that it's the primary piece of legislation at a Commonwealth level. Have a look at Chapter 5. You'll see that Chapter 5 is huge and it covers a good part of the Act. And there are 4 main areas there. There's identifying and monitoring biodiversity and making bioregional plans. There's processes dealing with species and communities, conservation agreements and protected areas. So tonight, just to select one, I'll have a look at protected areas, and you would have seen that within the definition of Commonwealth protected areas, there's really 9, and one of those is the Great Barrier Reef, and another is Commonwealth Reserves. So again, just to select 2 of those, I'll make some comments about them. Firstly, Commonwealth Reserves. You would have seen in your reading sections 344 and 345 of the EPBCA allow the Governor-General to declare areas of land or sea as Commonwealth Reserve, and the Director or Board of the Commonwealth Reserve must prepare a management plan. That's section 366. So that applies generally to Commonwealth Reserves. The Great Barrier Reef has its own piece of legislation. That is the Great Barrier Reef Marine Act 1975, and that's the primary act relating to the marine park. Now, even though, and I've just selected those so that if you want to target your reading, just have a look at what I've outlined. But the same thing applies for different areas of Commonwealth protected areas and of course the different areas under commentary in Chapter 5 of the EPBCA. So that'll do for the Commonwealth commentary. But bear in mind, of course, that it's not just the Commonwealth that deals with natural resource law. The states have a part to play in that regard, and in particular, have a look at the Environmental Protection Act 1994. And the object of the Environmental Protection Act is to protect Queensland's environment. However, and this is very common throughout the themes that you would have seen, while allowing for development that improves the total quality of life now and in the future in the way it maintains the ecological process on which life depends. So that's Section 3 of the Environmental Protection Act. Now, the reason I'm highlighting that is that, as we said last week, even though this is a course on environmental law, it should not be assumed, and it's not the law, that everything is about protecting the environment. The concept of ecological sustainable development means that we must bear in mind that balance between development and the interests of humans, as it were, as well as the environment. So the Environmental Protection Act, if you look at the definition in Section 3, gives preeminence to the ongoing welfare of human beings because it talks about protecting the environment while allowing for development that improves the total quality of life. And when we're talking about the total quality of life, we're talking about human life in that context. And development in that context clearly talks about economic development. When you're considering a question in relation to a legal topic, one of the first things that I think you should always do is go back to the object contained in the Act and work from first principles, and then everything works within that context. All right, now, when just on the Environmental Protection Act and natural resource law, we need to start to consider the criminality imposed upon offenders, and the Environmental Protection Act is a key piece of legislation in Queensland in that regard. So essentially the EPA provides for criminal sanctions against a person who causes environmental harm through an activity. So I do want you to have a look at this very carefully. Perhaps you could even consider this as an exam tip. But Section 319 of the EPA places a general environmental duty on all members of the community to ensure that environmental harm is minimised. So just bear in mind that general obligation, and all members of the community are covered by that. However, Section 505 of the EPA provides that an application for an order to remedy or restrain an offence or a threatened offence may be brought by the Minister or an administering authority or someone whose interests are affected by the subject matter of the proceedings or someone else with leave of the court. So have a look at Section 505 subsection 1 of EPA, because it provides very wide basis upon which a number of people can bring an application for an order to remedy or restrain an offence against the Act. So that's what brings in the criminality. So we're used to, an offence is committed. What happens? One of the local police come along and arrest someone. That's the way we think about it in terms of criminal law. But I'm going to ask you to think more broadly when it comes to environmental criminality, because of the way in which Section 505 of the Act is drafted. In the context of criminality, also think about the types of causation, and I'll give you some examples. Section 4371 of the EPA says that a person must not willfully or unlawfully cause serious environmental harm, and 4372 provides that a person must not unlawfully cause serious environmental harm. Now, if you look at that, you'll see that the word willfully is what makes the difference. So when we talk about causation, it might be a willful act, or it might be something other than a willful act. And it may be that an act is unlawful if it causes serious and material environmental harm. And that therefore means it's very broad in its application. However, the mere fact that some environmental harm is caused does not mean that a person must be responsible. It is a defence to prove that the harm occurred even though the defendant was complying with his or her general environmental duty. So have a look at the defence provisions as well. But what I'm going to do is invite you to have a look at, and I think these are in the notes, have a look at the Section 437, 438, 440, 442, 443 and 444. Now, all of those are under the Environmental Protection Act. Okay. The other piece of legislation in Queensland is the Vegetation Management Framework Amendment Act 2013, and that amends the Vegetation Management Act of 1999. Again, we go back to the objects and the purposes of the Act. Have a look at Section 3 of the Vegetation Management Act of 1999, and you'll see what the purpose is in relation to the clearing of vegetation. And it's not just a matter of saying you cannot clear vegetation. There's a balance. And one of those balancing factors is to allow for the clearing of vegetation that allows for sustainable land use. So I guess there's a lot of criminal defence lawyer in me that I'm always looking at the objects of the Act to determine whether there is some basis upon which a person who's being prosecuted can argue from first principles that what they were doing was in fact authorised by reference to the object or the purpose of the Act. But nevertheless, there are many land clearing offences that are prosecuted, and some of these can be of very significant amounts of money. So again, it might be in the notes, but have a look at a case called Newcastle City Council against Pepperwood Ridge, P-E-P-P-E-R-W-O-O-D Ridge, Pty Ltd. It's 2004, 132 LGERA 388. Essentially in that case was a plea of guilty to land clearing, and typically what happens on a plea of guilty is that the court will provide a discount on penalty. In the criminal sphere, I will often ask for a discount of a third to properly reflect the benefit to the prosecuting authority in the defendant pleading guilty. In that case of Newcastle and Pepperwood, the discount was 15%, which is probably a bit light on, I should think. In any event, to reflect the gravity of the offending behaviour, in that instance, the court imposed a fine of $68,000 for illegal tree removal. However, that was itself a substantial penalty, and the reason that the fine was low was the defendant undertook to pay the council's prosecution costs, which, and you'll see this at 31, the council estimated those costs to be between $100,000 and $150,000. So potentially the real financial penalty was up around that $220,000 mark. So quite substantial. So it can be, criminal proceedings can be a great deterrent in terms of natural resource law, but as we've seen, there are other ways that this can be done. And Section 505 of the Environmental Protection Act that I mentioned before is an example of how there are other ways to deal with what might be perceived as straightforward criminality. Now, just speaking of natural vegetation, I just want to mention offsets. Offsets are really important in this context, and it's just another way of dealing with reparation for natural vegetation loss. And the extent and the nature of the offset is usually determined through negotiation. So if you're advising a person who's involved in the process of tree clearing, well, I guess one way to deal is they can run the gauntlet, do what they need to do, and then deal with the prosecution that might follow afterwards, or they can negotiate through offsets in particular. And of course, that's what I'd recommend that we do. Now, the EPBCA at the Commonwealth level does not directly apply in relation to protection of native vegetation, but prosecutorial authorities may rely on other provisions to prosecute the effective clearing of vegetation. And again, the penalties can be substantial. So the first one that I talked about was state prosecution. That's the Pepperwood case. The Minister for the Environment, Heritage and the Arts against Lamentina, L-A-M-A-T-T-I-N-A, is a case referred to 2009 FCA, Federal Court Australia 753. That's Minister for the Environment against Lamentina. In that case, there was dealing with prosecution regarding an impact on a threatened species of cockatoo, and that was against Section 18.3 of the EPBCA. And in that case, the court imposed a fine of $220,000 and fix the costs at $22,500. So pretty much the reverse of the Pepperwood situation. Similar ultimate dollar figures, and a much greater fine and much lower costs. I guess if you're advising someone in that situation, you might want to talk to them about that. I would think that it's better politically for them to be paying a lower fine and more costs rather than the other way around, particularly if you've got a company that's a public company. Anyway, that's an issue that might be considered. All right. In the material, you'll see this commentary about declarations and enforcement orders. Now, the Planning and Environment Court in Queensland, so we're back to the state jurisdiction now, has power to make declarations. It's what we call an equitable remedy. And a declaration, as the name suggests, is really the court saying this is the law in this particular issue. So one thing that you can consider if you're prosecuting a matter which involves natural resource law, or you're defending a matter, is perhaps it may be appropriate to consider Section 456 of the Sustainable Planning Act, which provides the P&E Court with power to make declarations. Alternatively, it might be appropriate to seek mandatory injunctive relief and have a look at sections 601 and 604 of the Sustainable Planning Act. Now, I know these terms probably sound difficult. Oh, what's a mandatory injunction? What's a declaration? But in essence, they're pretty straightforward. A declaration is the court saying, all right, well, in relation to this question of law, we now make a declaration. This is the legal answer. An injunction is usually an application or an order of a court, rather, to say stop. A mandatory injunction is an order of the court to say you must do something. You must do something. So these are important because they're all options that are available to people that are involved in this area of law to consider. And it might be that an application for a mandatory injunction pursuant to Section 601 of the Sustainable Planning Act is a more sensible way of dealing with an issue than perhaps a prosecution under the Environmental Protection Act. Not sure, but these are things to consider. And I think some of the cases that we've referred to in the notes certainly will provide some commentary, and I'll refer to one shortly. So another thing is that, so just to bear in mind that a person can bring proceedings for an enforcement order to remedy or restrain the commission of a development offence, and that's Section 601 of the Sustainable Planning Act. That's part of the mandatory injunctive relief provisions. And Section 604 that I mentioned before empowers the court to make an order which is making an enforcement order. And the court can make an enforcement order if they're satisfied the offence is committed or will be committed unless it's stopped. And if the court is satisfied the offence has been committed, the court may make an enforcement order whether or not there has been a prosecution for the offence. So think widely and definitely have a look at Section 601 and 604. Now, for a real-life example of that, there is a recent a recent case commentary, Fraser Coast Regional Council against Bird Brothers. It's in the Planning and Environment Court. You should know how to get to that case by going through the court's website. We had a look at that, I think, early on. Does anyone remember that we went through courts and we went to find that particular case? If you have trouble, let us know, but go to the court's website. Let's see if I can dig it up as we're talking. And in that particular case, the order that was sought was an enforcement order pursuant to Section 601 of the Sustainable Planning Act, restraining the respondent from carrying out accessible development in certain circumstances. So, look, I'm just going to show you this court's website. If I'm repeating something I've already done, please excuse me. I'll see if I can share the screen. You should now see my screen, and you might remember this thing here, this search civil files. This is great because it means you can do a party search, because some of these cases, they're not reported in the usual sense, so you have to go searching for them a bit more. And here, if we see party details, the last name, Fraser Coast Regional Council, we'll search for environmental law cases involving Fraser Coast Regional Council. If we scan down, so I hope I'm not giving you a headache by blurring that quickly. You'll see here case of 4926 of 13, Fraser Coast Region against Byrne Brothers. That's the example that I'm giving to you. And over here, you can view the file details. And if you view the file details, you'll see all the things that happened in that case. And further down, you've actually got the documents. So one of the things that you can look at is the originating application. So it's here. We'll click on that, and you'll see what the court ordered in that instance. If I can find it. Get rid of all these other things. I know it's here somewhere because I clicked on it. Sorry, I don't know if you're like me, but you have thousands of pages open, and people tell me I shouldn't do that. Okay, I'm sorry, I'm not finding that document. It's probably there somewhere, but have a look for that for yourself. I'll stop sharing the screen now, otherwise I'll confuse myself even more. But what you would have seen if we'd been able to open that document is the nature of the relief sought. Okay, so there's a lot of reading in the material. There's a few questions, I think, for you to answer in the weekly problems. Speaking of weekly problems, I would like to just briefly talk about the problems from last week. And I'm going to just refer you to the notes from last week in the context of answering the problems for the weekly work. So I'm going to share the screen again. And these are my original notes. Well, I shouldn't go through that. What I'll do is I'll go through this. And I've just created some commentary in relation to the problem of environmental impact assessment and approval process that we did last week. And this is taken from my study guides. And I'll just read from some of that. But you can read this for yourself. It is important to understand that environmental assessment is a feature of strategic environmental planning, and it must be consistent with the objective of attaining ecological sustainable development. So bear in mind that definition again. In the notes, you'll see that there are some specific purposes for undertaking environmental impact assessment. There are a number of steps, and you'll see those in the notes. And I've just made the extra comment that, in essence, an environmental impact assessment, EIA, comes about following the preparation of an environmental impact statement, usually by the developer, and its review by officials. And then in the notes at part 3, I talk about the intergovernmental accreditation of environmental assessment. I refer to section 3 of the EPBCA, and then go on in part 5 of the notes to talk about national environmental significance and controlled actions and the test associated with determining whether or not a proposed action needs to be referred. So it's pretty simple. When we're talking about controlled actions, you must firstly consider whether the proposed action is likely to have a significant impact on a matter of national environmental significance. And the second question is whether the proposed action is likely to have a significant impact on the environment in general, and that's for actions by Commonwealth agencies or actions on Commonwealth land, or the environment on Commonwealth land. So they're really the two questions. And in essence, the test to determine whether or not the action is a controlled action is whether it is an action for which approval is required under Part 3 of the Act. And that's really the test that I just mentioned there before. Once it's determined that a project is a controlled action, it may be assessed at both state and Commonwealth. The first test determine, as I said before, whether it's national environmental significance or involves protecting the environment or that involves the Commonwealth. Okay, so I'll put that answer up on the website. And if you are answering those questions, please continue to do so. I'll stop the share now. I appreciate I've been doing a lot of talking. Are there any questions before we finish for tonight? All right. So what I will do is accept all the first assignments by 11:45 p.m. tonight, that is the 5th of May. I will then allow people to submit their work if they're late up until Saturday week, which I think is the 14th of May. But 11:45 p.m. on the 14th of May, whether you've had an extension granted or not, that's the cut-off, because what I like to do is provide marks and feedback the next day on the Sunday the 15th. It may be the 17th, it may be the Monday, but I aim to provide that. And I can't provide that feedback or those marks if I've got people outstanding, so that's why I always have a cut-off on the Saturday night. If there's any questions about that, please let me know. And of course, submit your work in the one document if you can. And if you need to ask for an extension, do so by 11:45 p.m. tonight, because I won't accept any applications for an extension of time beyond that. All right, so my voice has held up tonight, just. Thank you for bearing with me, and we'll see you next week. All the best.